More student loans in the news, so we are going to talk about that today, specifically the SAVE plan, and officially actually coming to an end because of court order. All right, we'll get to it in just a minute, but first, anytime you hear a topic discussed on the podcast, there's always an article associated right along with it, so you can dive in deeper and get all the links and resources you could possibly need about the topic. It's all at thecollegeinvestor.com. If you like the podcast, you can just kind of copy and paste the title of the podcast right into the search bar at thecollegeinvestor.com, and you'll find the article. You can also ask questions, like us, get to know us, leave comments, all those things on social media. Just search for the words The College Investor and you'll find us. All right, let's take a look at this. It's the SAVE student loan plan officially coming to an end by court order. The SAVE student loan repayment plan is dead. Moment of silence, please. Okay, that's good. And a federal appeals court just made that official. The U.S. Court of Appeals for the 8th Circuit ruled on March 9th, 2026. You can even find and read the ruling, if you'd like, at thecollegeinvestor.com, that a lower court wrongly dismissed the Republican state's lawsuit against the plan, directing the district court to enter a December 2025 settlement agreement that permanently bans the Biden-era income-driven repayment program. The request to force the joint settlement was one of the alternatives presented in the GOP appeal to the 8th Circuit Court. Here's what borrowers need to know. First, the background, the legal fight over SAVE. Okay, so the SAVE plan, Saving on a Valuable Education, was created by the Biden administration in 2023 as a revision to the existing REPAY, which is the Revised Pay As You Earn income-driven repayment plan. Established under Section 455 of the Higher Education Act of 1965, SAVE offered lower monthly payments and accelerated loan forgiveness timelines compared to earlier repayment options. 7 Republican-led states, Missouri, Arkansas, Florida, Georgia, North Dakota, Ohio, Oklahoma, sued to block the plan in the Eastern District of Missouri, arguing the administration had exceeded its statutory authority in creating the thing in the first place. Federal courts agreed. The 8th Circuit issued an injunction halting SAVE in 2024, placing enrolled borrowers into a payment-free forbearance while the litigation proceeded. Okay. After Trump took office in January 2025, his administration and the plaintiff states negotiated a settlement, which both sides signed on December 9th of 2025. The settlement would have resolved the litigation by having the federal government agree to permanently wind down SAVE. However, the district court dismissed the case instead. That dismissal triggered the state's appeal to the 8th Circuit. All right, now you're caught up. So here's what the settlement agreement requires. The December 2025 settlement is sweeping in scope. Under its terms, the Department of Education must do these things: stop enrolling any new borrowers in SAVE, and deny all pending applications, continue moving current SAVE borrowers to other plans, refrain from forgiving loans under SAVE's income contingent repayment authority as interpreted by the SAVE final rule, not implement any provisions of the SAVE plan final rule, with one narrow exception, a provision about deferment and forbearance counting toward forgiveness eligibility, which took effect July 1st of 2024 and was really never challenged in the lawsuit. Not revive or enroll borrowers in the original REPAY plan. Pursue formal rulemaking to officially repeal the SAVE plan final rule, consistent with the One Big Beautiful Bill Act signed into law on July 4th, 2025. The settlement also creates an ongoing notification requirement. If the department plans to forgive more than $10 billion in federal student loans in any single month, it must give the Missouri Attorney General's office at least 30 days written notice, identifying the legal authority used. That oversight provision runs for 10 years from the date of the agreement. The settlement creates no third-party beneficiary rights, meaning individual borrowers cannot use it to sue the government. Here's what this means for borrowers. For the roughly 7 million borrowers who are in SAVE forbearance, the 8th Circuit's ruling cements what has been apparent since 2024. Save is dead. Borrowers currently sitting in Save forbearance will need to transition to a different federal repayment plan in the future. Exact Save timelines still to be determined. The department said in the original settlement agreement that additional communication will be coming soon. Borrowers currently have the options of income-based repayment, IBR, pay-as-you-earn, PAYE, PAYE, and income contingent repayment, or ICR, and the standard repayment plans. It's important to note that both PAY and ICR will phase out by June 2028, and depending on timing, borrowers may be able to directly enroll in the new Repayment Assistance Plan, or RAP, which launches in July. That is also a good plan. It's important to note the settlement does not eliminate all loan forgiveness pathways, all right? Borrowers enrolled in SAVE can still receive forgiveness through these things: Public Service Loan Forgiveness, PSLF, Borrower Defense to Repayment Discharges, Total and Permanent Disability Discharges, Closed School Discharges, and Death Discharges. Those programs rely on separate legal authority and are completely unaffected by the whole SAVE settlement thing. Okay, now, here's what comes next. The Eighth Circuit's ruling orders the Eastern District of Missouri to enter the settlement as final judgment immediately. The emergency motion the states had filed to get an injunction is now moot because the settlement will take effect. So for borrowers in SAVE, it's more important than ever to do the math about whether you should change repayment plans right now or continue to wait in forbearance. For borrowers pursuing forgiveness under PSLF, you gotta do it now. It's better to change now. So for right now, all borrowers in the SAVE forbearance, 7 million, will need to wait for further guidance from the Department of Education. You can check for updates on the Court Actions page for future communication. If you want to put that in your favorites, check this article out at thecollegeinvestor.com. Right at the end of the article, that's the link you need to do. Click on that Court Actions page link. It'll take you right to where you need to go to keep up to date on all of this stuff. But again, if you're pursuing PSLF, change to a different plan as soon as possible. That is our show for today. Hope it was helpful to you. If it was, hit a like, subscribe, all those things. We'd greatly appreciate it. Also, share this with somebody who could definitely use this information. Anybody in the SAVE forbearance needs this info. You can save it. We'd love it. You can also follow us on social media. Get to know us. We'd love to help you wherever you are in your money journey. Just like, follow, all the things. Search for the words The College Investor and you'll find us. Thanks so much again for stopping by, and we will talk to you again real soon.